All right, good afternoon, everyone. It's a pleasure to be on this webinar with you all. I really appreciate everybody showing up to be on this meeting. We're really excited to share some fantastic information with you. I'm Brady Held. I'm the CEO and founder of Courtroom Animation. And just real quickly before we get started, I'm going to introduce our sponsors, as well as Steve and Jerry Marcus. But quickly, a couple logistical items. First, this webinar is going to be recorded, so we will send a follow-up email probably first thing next week with a link to the webinar so that you can view it, and if there's anything that you want to remember in the future, or if you want to share it with other people, you'll have that link. Also, we're going to be showing a lot of videos during the webinar as we're talking about using exhibits to help settle cases. So as with all streaming video, there could be some video hiccuping or some audio issues. We'll do our best to alleviate those, but all the videos will also be emailed to you so you can have access to really high quality versions of these exhibits after the fact. Lastly, there's going to be an interactive webinar. So use the Q&A, the question and answer function. Ask questions to Steve or Kelly or myself or Jerry. We'll do our best to look at those questions and answer them as we get going. So yeah, again, really excited to introduce everybody here. First, I want to introduce Kelly. Kelly Deutsch is the executive producer and co-owner of Verdict Videos. She's been producing legal video documentaries since 2005. She helped establish Verdict Videos back in 2010. And Kelly's been in broadcast television as writer, director, and producer. She was doing that for 12 years. And what I can say about Kelly is, she's 100% committed to Verdict Videos' tagline, which is winning matters. And when you see her videos are incredible. The best attorneys in the country use Verdict Videos, and you see these and you get that winning matters. Really, really incredible. So Verdict Videos is one of the sponsors. Courtroom Animation, my company, is the other sponsor of this event here. So again, I'm Brady Held, the CEO and founder. We're based out of Los Angeles. We've worked on over 1,600 cases. We do a lot of personal injury cases, products and premises liability, high-profile homicides and police shootings. I've personally worked with the U.S. military, developing virtual reality programs to help treat soldiers with PTSD. And I've testified as a forensic animator, both in state and federal court across the country. So it's really a pleasure to be here, and I know Kelly feels the same way. So now, our attorneys that are going to be kind of running this thing. First, we have Jerry Marcus. Jerry has a fantastic firm out in Calabasas. He's represented over 15,000 clients. He has, I think, over $250 million in settlements. It's legendary, Jerry Marcus. And then Steve Vartazarian, the man of the hour on the show. I've worked with Steve for many years. I've had the pleasure of working on a lot of cases with him and helping his clients, collect millions and millions of dollars. He's on the board of ABOTA, American Board of Trial Attorneys, serves on the board of the Consumer Attorneys Association of Los Angeles, the Trial Lawyers Charity, and most recently, big things about Steve, the 2019 CALA Trial Lawyer of the Year. Last year, he obtained the highest pain and suffering damage award for a single plaintiff in California history, $113 million verdict. He has awards kind of left, right, and center. I'm not going to get into all of them because we'd be here all day talking about how great he is. So instead, we'll just listen to him, and hopefully he can impart some of that greatness onto us. So without further ado, Steve Vartazarian.
Thank you so much. All right, for this webinar, this is my 12th webinar since the quarantine started. So I'm getting better and better at it. I'm going to get right to the point so we can keep this about an hour long. Well, it's for me nowadays, settling cases is what I need to do and what I need to focus on for my practice that I've realized. The days of trying to get verdicts, making a point, trying to win awards and stuff like that, they have their place. But settlement brings resolution quickly. You get paid quickly. We have this big glamour of, oh, we hit these big verdicts. Well, let me tell you about those. Getting paid on those takes years, 2 years, 3 years, appeal. Now at the end of the day, you could take, 7 million or 700,000 today. Maybe you can get 15 million 3 years from now, but that road there is difficult. And not all people who are on that wagon, so to speak, can weather waiting that long to get paid on something like that. And so I don't advertise settlements that much anymore. I used to post settlements here, we settled this. And the reason is everyone should be, can, and does be settling cases. It's not that big of a deal. It is a big deal when you settle a difficult case, or when you get a defense attorney or difficult defense adjuster or whatever to pay you top dollar on a case that they originally thought was crap. And so that's what this webinar is going to be focused on, how we go about getting them to pay us. And I've learned, as we all have, we go to mediation. Before we get there, we've been litigating the case for like a year and a half, okay? Depots, experts, you got great liability, crazy damages, coverage, and you got, everything's great. And then you get there, you're sitting at mediation, and some, mediator walks over to you on a case where it's worth like 10 million bucks, like on any day you could try it. Anyone could try to hit it for 10 million. And they're like, yeah, their opening offer is 100,000. I'm just like, you know what? I've almost been banned. I'm not going to say from which mediation companies, because on those occasions, I'm waiting. I've waited 3 years to get to this mediation, and now all of a sudden, I'm pissed. I'm like, wait, what? That's why I end up in trial so much, because once I hear crap like that, I get up without saying anything to anyone. I don't make a scene. I don't tell the mediator. I just leave. I drop off a check. I tell the person in the front, I'm paying for the entire mediation. I don't want to be rude or waste anyone's time, and I'll just leave. Because that's bullshit. You can offer me 100 grand on a case that's worth 10 million. And I've walked into their room on other occasions. I've exchanged, some not too kind words, and I've walked out. And, you're not supposed to do stuff like that. But that's why I ended up in trials as many times as I have in the past 10 years. Because either when the defense attorneys and the adjuster and the mediator walk in and they tell you, well, they've offered you 100,000 because your case has a lot of problems. The plaintiff this, the comparative fault that, the policy may not be open this, or whatever, all the causation on the injuries and the medical expenses and the liens and this, that, when I thought I had everything perfect. Either I'm crazy or they're wrong. And so I've come to believe that they're wrong. I don't think I'm crazy. I mean, maybe, in my personal life at home or whatever, but in reality, when it comes to evaluating these cases, I think I've got it dead on. And the reason is we've worked it up. We've talked about it until, if we talk about it anymore, our paralegals, they can overhear us in the conference room or whatever. They've threatened to quit. Like, if you guys even talk about this case one more time, we talk about it to death. We do, all these focus groups, and we make sure that ordinary folks that are going to be our jurors at some point, they see it the way that we see it. So when we get to the mediation, we're expecting opening offer of, 20, 30% of what our demand is. And so when we don't get that, now we began to understand why, which is what I'm going to talk about next, and how we use visuals in order to bridge that gap. All right, so Jerry, you've had this experience, have you not? I mean, you've been doing this a lot longer than I have. Have you been in this position?
Absolutely. So I've been doing this 33 years. And at the beginning of my career, I tried a bunch of cases. And then I realized, after having tried a bunch of cases, that there was really no shame in settling a case, provided you developed the case properly and you got the number, the fair value that you believe the case was worth. And if you can't get it, then you have to go to trial. But without exception, my experience within the last 5 to 10 years, no matter how well I've prepared for the case, if you don't come in with both guns slinging, with complete development, with your animation, your day in the life, with all the demonstrative, they're not going to pay you the money. And even if they don't pay you the first mediation, there's always a second opportunity to get the full value of the case and avoid going to trial. So the way I approach it is to do everything I can, get top value, to try and avoid going to trial. And if we have to go to trial, then I'm going to bring in somebody like you.
Thank you.
What it
Yeah,
is.
so, somebody told me a long time ago, it's the defense attorneys through the insurance company's job to keep us plaintiffs' attorneys poor. Even you settle a case, we don't talk about when they're going to pay us. 6 months later, we still don't have a check on a release we signed like 6 months earlier. So they make it really hard for you to get the money. And even coming back into the case, discussing the merits of a particular case, we've realized why. There's several factors at play. One, I get along with some of these defense attorneys. Others of them I don't get along, and others of them I don't even talk to them until the first day of trial. But the point is that they are not going to put your case together for you. It's necessarily an adversarial process where they're trying to do, even right now, as we're sitting here quarantining, I'm sure there's Zoom defense attorneys doing a conference on a case that I have, trying to figure out how not to pay me. And so that's kind of their job. And so when we get to a mediation on a case that we think is great, we've prepared, we focus group, we bring videos of the focus group where we did a better job arguing the defenses than they did, and we get the slow ball offer. Now I'm not surprised. When it happens so many times over the course of so many years, I realize that they're adversaries of yours by just nature of the dynamics of the relationship, and they don't see your case. They don't see your liability the way that you do. They don't see your damages. And not only do they not see it, when you tell them about it, they begin to, they're just natural reflexes to dispute it. So we started thinking about how to get money faster, settle cases faster. For every case I try, I settle like 50 cases. Some ratio like that. And so we realized that visuals, video, animations, they're the way to go. Let me tell you what I mean. I get on Instagram at night, just scrolling through, people's these videos and all that. I find a cat, there's a meme, there's a piece of bread, and there's a hole in it. The cat's face, it says cat inbred. I watched the video for like 5 minutes and stupid. You know what I mean? But I can't help it. I can't help it. I'm going to watch it. I get on, 1 a.m. I'm about to go to bed. I get on Instagram. I see Jerry Marcus peeling mango. I'm going to watch it. I can't help it. I got to see what he's doing. Okay. So, we realize that it's just human nature. You want to watch stuff. But when you give defendants depositions, when defense counsels, they're watching you depose their client, reading discovery responses, it's not video. I don't know why, but the nature of that medium of information, it's not well received or digested, as is a video that you get to sit alone at home or in your office and watch by yourself at your own leisure, scroll back and forth, and look at it. And so when we realized, we're like, oh my God, if we send a defense attorney a video or an adjuster a video, they have to watch it. How can they not watch it? I've never sent them a video, and I'll ask them after the case settles. I'll say, we sent you this DVD. How long did it sit there? Oh, well, it sat there for about a day or two before we circulate it. That's the other thing. They have to circulate it once they watch it. So now what we do, we don't send CDs or DVDs of stuff. We send links to animation, settlement videos, and things like that, because you could click on it and watch it immediately. So here is how we've used these to settle cases like fast. Or, once I get into the case, it's all about trying to settle it first. And here's how we go about doing it on relatively tough cases. So if I have a case, I have no case that I start right from the beginning. Our cases come in like midway through, most of them. Some cases that we do have that start from the beginning. And so what we've done is I call Brady Held from Courtroom Animations or Kelly from Verdict Videos. We do a day in the life. We do animations early on without even having experts. You don't need experts to do animations. These outfits are sophisticated enough to have surgical animations done, to do accident reconstructions with foundation. They go out, they do their own thing. You don't need to pay your animator and an accident reconstructionist or biomechanical person or an orthopedic expert to do these animations. We do them, and then we use them. And if the case doesn't settle, then later on, we'll retain experts to bless these animations, and maybe they'll make a tweak or two, but for the most part, they're pretty accurate now. Everyone knows what they're doing to a point where they can get them accurate. So if we have cases that start from scratch, even in our form interrogatories, our responses to what are your injuries, 6 series, we don't put anything in writing anymore. We've been doing this now for, I think it's about 6 months to a year, where we will make a day in the life video, and at 6.1, where it says, what are your injuries? I think that's the one that says it. We will say, see attached exhibit 1. And it's a day in the life video. And it's the first time I've got some defense attorneys and adjusters call me. They're like, I've never seen a day in the life video attached as a response to a form interrogatory asking what injuries do you claim? But when they see that, they have to circulate it. And now all of a sudden, when they see something like that, a year and a half, 2 years later, right before trial for the first time, oh, well, now we got to evaluate this and get authority. So it kind of helps things along. And then when we get to later on in the 20 series where it says, describe what happened in the incident, we attach an animation. We attach an animation of the incident. This is what happened. And so we've noticed that as we start giving them more visuals, the more responsive they are to knowing what the case is. Because now, instead of advocating against your position by nature of the dynamic by default, just as a reflex, just saying everything you have is bullshit. Now what they're doing is they're looking at what we're sending them, and they're using it to evaluate exposure, coverage issues, viability of their defenses. The dynamic changes when they see these things early on. And so we've noticed that it's a tremendous help. And we're settling cases within 6 months to 8 months of filing, where before it would be about a year or 2 years later. So what we have prepared today, and I hope some of that makes sense, what we have prepared today is a settlement video that Jerry and I worked on a case together. And I'm gonna let Jerry talk. I'm gonna talk about the case a little bit. The settlement was confidential. The email blast that we sent out is not the case. This is a different case because this case is confidential. And it was an extremely, extremely difficult case. And as Jerry and I worked together on the case, our jobs were to get the case resolved. Every time I get into a case, my job is not to try the case. My job is to get the case resolved. That's what I go to. It just so happens that we know what value we want through focus grouping it and all the other things. I did a different webinar on that a few times in the last week or so. So I know the value. And I just want you to pay like 80% of that, 70% of that. I'll take it. I'm not trying to make a point. I want to get the money and move on. Now, if you don't do that, you will end up in a trial with me. And I don't think it's going to go well for the defense because we're extremely prepared when we come to trial, but that's not the point of this webinar. But I don't want to do that unless I absolutely have to, because I shut down everything in my life and it's the only thing that I do for 2 months. So let me tell you how we used verdict videos in conjunction with courtroom animations and a voiceover to create a settlement video that got the crappiest, or what appeared to be the hardest case to settle ever. Like the defense will do 0 offer. This case is crap. And let me tell you some of the facts, and then I'll let Jerry chime in and talk about the client a little bit. Okay, so every time you get a case with horrific injuries and coverage, you sign that up and then you find liability. Well, this was kind of one of those, This was kind of one of those. But at the outset, there appeared to be a lot of liability. A lady got ran over by a bus. Twice, by both wheels. Ran over her torso, just shattered everything inside of her body from neck all the way down to her toes. Just shattered everything. And so what happened with that was this. She was in Pure Blossom, in Antelope Valley. She was semi-transient. She lived in the back of a trailer park somewhere with somebody we really didn't know. She walked over to her friend's house like 11 p.m. the night before and stayed there. She was a known meth user, known heroin addict. She walked over to her friend's house at 11 p.m., stayed awake until 6 a.m., God knows what she was doing. And at 6 a.m., she ventured out into the street to walk to her trailer park, which was a few hundred feet away. It was alleged that it was pitch dark on the street where she was at. There was no lights. She was on meth. She darted out into a dark roadway, and at 6 a.m. there was a school bus coming to pick up children from the intersection where they had gathered to go to school. And she darted out in front of the school bus, cracked out, wearing all black, and was run over by the bus with no warning to the bus driver. And the ambulance came, they found a heroin needle in her bra. She had found out later she'd been arrested before, and she was a disaster. Jerry, I'll let you take it from there.
Okay, thanks, Steve. So that's a good description of the case. And again, the injury drives the case. So this came to us after actually, I think 2 law firms passed on the case. One attorney took the case, saw the police report, and dropped the case. Of course, the police report was horrible against our client. A little bit about the client, and that's probably the biggest hurdle that we have when we have a tough client and trying to humanize them to the defense. And that's really where Kelly comes in, which she did a phenomenal job, and you'll see about that in a little while. But our client was in her early 30s. She was homeless, meth addict, heroin, alcoholic, criminal record. She had a couple of prior suicide attempts, 2 or 3 overdose situations, all within a year or so before this accident. That was the start of the case. As we developed in the investigation and finding out more about her injuries throughout the course of this case, this is the difficulty of a really tough client. Our client would kind of go off the radar. We would just lose her, and we would literally have to send out a bounty hunter to track her down, to get her, and to protect her from herself and for her case. So we handled that over the period of about 1.5 years, all the way through, and Steve will address some of what we did through the latter stages of discovery and then the demonstrative part, but all the way up through trial, which was very interesting. Steve.
So I want to say this. I got some questions here. I'm going to answer them here in a moment. I want you guys to know that I did not start out litigating 10, 20, $30 million cases. I started out with crappy med mal cases that I would settle for $29,999, $1 less than the cap with which the physician would have to report themselves to the board. I would get $12,000 in fees. I would try to do that once every month or 2. This is back in 2009, 10. And I would have to pay $2,000, $3,000 referral fee. Those are the cases that I had. I had cases that my first few verdicts, $5,600. And people would make fun of me because I wouldn't even get the limited jurisdiction limit on damages, $10,000. I would bring in verdicts for the, what's it called? The small claims, under the small claims cap. So those are the cases that I started working on. And I ended up where I ended up doing just these exact same things. So keep that in mind. I was some small firm in Sherman Oaks, started on my own. Everyone told me, you're going to fail, this, that, whatever it is. But it's the ability to be innovative, creative, and do a lot of the legwork yourself that got me these bigger cases. And there's a lot of other reasons I've discussed in webinars, in the last week or 2, how I got here. It's through trying cases, different webinar. But I want to answer these questions, guys, with that in mind. Well, question 1, how are we supposed to do these animations when our cases are worth less than 100? Well, here's how. I do animations in almost every case I have. And I started doing animations with cases that were worth less than 100. And nowadays, what can happen is this. First, if you tell your clients you want to do an animation, they're like, oh my God, they're blown away, Oh, that's great, because now you're doing something that no one's going to do that. No one does this stuff. They let the case just sit there until right before the trial or experts, and then they get to it. We're proactive. We nail it from the front end. And so what we try to do is load it up heavy on the damages and all the evidence that we have to get it resolved. So to answer your question, Kane, I call every vendor that I know, and I just ended up using courtroom animations more than anyone else and verdict videos, because I tell them, I'm like, listen, guys, can you do something for me? Here's my budget. My budget's $5,000. I have a $100,000 policy case. Case is probably worth, I could settle it right now for 90. The offer's 18 in pre-lit. I could take a couple depos, I'm gonna file it, but what can you do for me for X amount of dollars? And see what you can get done. And the stuff that they come up with, they have libraries now where they're reusing things that they've already made and sold, several times, so they give you a good break. You form relationships with these vendors. So I would encourage you, Kane, to give them a call. Like, call them and see if they could do, a knee arthroscopy video for you of your client. Just change the face a little, give them a picture of the client. They make it seem like it's the plaintiff, and it's very effective. So if you have $5,000 budget or something like that that's reasonable given the value of the case, call your vendors and ask them to work with you on that. Next question. Steve, obviously you're getting some great settlements before using visuals. Getting some great settlements before using visuals. Do you have enough data to analyze whether your settlements are higher or faster? Okay, before using visuals, listen, here's the deal, okay? People think, oh yeah, trial lawyer year, this, that, you just put your name on a case that's gonna settle. No, I'm here to tell you right now, what it does do is this. They know that you will go to trial. They know that you have a significant track record. You're not losing. They know that the verdicts you're getting are disproportionate with the data that's out there. A leg fracture is worth 100. I hit it for like 3 million. I do that 10 times. They know the way that I work up my non-economic damages and explain it to the jury, they're in tears by the time I'm done. So because of that, the cases that are good and are gonna settle anyway, it's good that they'll pay you on that. They won't wait until you bring someone in. So when or at least at that time when I was referring cases out, before I learned how to do this, now when I come on board, they know if it's a good case, they're gonna pay immediately because they know I'll do it, so it takes away that lead time. But if it's a case like this, they don't give a shit who you are. They're gonna make you work on it because they think it's crappy, and a good lawyer can make a good case great. However, a good lawyer can't make a shitty case good. You can't. If it's a loser, I don't care who's trying it, it's a loser. The facts have to be there. So I hope that answers that question. So yeah, we do get settlements before using visuals. However, on cases that are tough where the defense doesn't see it and I do, that's where the visuals, we get a lot of traction on those. Next question, and I'll begin this showing you guys what we did on this case. Do you recommend videos to describe emotional? Absolutely, absolutely. I recommend videos to show any kind of damage, be it, look at what's on, be it emotional distress or otherwise. Look at what's on the KC jury instructions for pain and suffering and all the other things that come with it. Loss of enjoyment of life, disfigurement, inconvenience, grief, anxiety, all these other things. And so what I do is I make a list. Let me move forward here for a moment. I make a list of all those damages. I go to lunch, dinner, weekends, wherever with my clients. I sit there and I do it 9 times or 8 times or whatever it is. If it's pain and suffering, all we do for that lunch for 3 hours is talk about pain and suffering. That's it. If it's emotional distress, we'll just talk about that. By the time I'm done, I have enough where I can call Kelly Deutsch and say, Kelly, we got to make a video. I want you to go. Here's what they told me. I write out the questions for her to ask, and she knows what to do anyway. And so we make a video of what their emotional distress is like after they lost the child. Or if it's in a smaller case, after they can't, drive anymore for, a year or move their neck or do other things. And we do it in a way that pulls on the heartstrings of people. And adjusters arguably are people, you know what I mean? So even though they hate you and they don't want to pay or whatever, let's say, I'm making an extreme example, they can't help but to watch it. And here's the thing about juries, about humanity. When somebody sees something that has an emotional element to it, they're going to respond. The heart and the brain work together. It's been like that since the beginning. That's the beauty of a jury trial. Since the beginning of man, whenever that was, I'm not going to get into it, but it doesn't matter. The point is, we have been wired the same way. Our brains are wired to our hearts. It's always been that way. And so when a human being perceives something, they're going to first have a feeling about it. Then it's going to go upstairs and they're going to think about how they feel, and then they're going to form an opinion. That's the process. That's a constant. That will never change. Your job is to take what you have and put it together in a way when they perceive it, they only come to one conclusion. So a lot of people say, oh, are you saying you can manipulate the way people form their opinions? Yeah, I think I can. Or if I can't, I could try. And the way that we've been doing it, it works. We put together something that's so objective, it can't be denied. If my case has those features, I'm going to go for it, and I'm going to trust the jury to do the right thing, unless the defense pays value. If the defense doesn't see it, though, right in the beginning, then I'm going to put together some kind of animation, videos, which we're going to get into right now, to try to persuade them to resolve the case. Here's what we did on those crappy facts. So I get this case, and, first, we don't want to let the client down. Everybody knows about the case. Everyone's heard of it, everyone, because we're attorneys. We're in a small community, Jerry and I. We talk about our cases, and people talk to us and stuff. And so everybody knew about this case. So everywhere I'd go, every mixer, every Cala this or KOC that or AHJ or whatever, people are like, hey, I heard you guys you guys got that case teed up for trial. What's going on? What's going on? And I'm just like, I don't know. Like, I just got it. The depots are in my office. And so I started reading the depositions in the case, and Jerry had taken all the depots, and he did a really good job. And their defense that she's a crackhead who was methed out the night before, didn't sleep, who was meandering in the middle of the street on her way home, and just this poor lady was trying to pick up kids and take them to school, and she darted out or whatever she did, wearing all black on this pitch dark street. Once I started reading this stuff, I realized that there may be something there. Let me tell you what I mean. So I think your name is Kane. You asked the first question. So what I did earlier when I didn't have the money, you guys, I want to stress, when we started doing stuff like this, I would have at times in my bank account $8,400, $3,600. And I'm not ashamed to say, I called my mom often in the first year or two of my practice, and I borrowed 10 grand, 5 grand here, 15 grand there. I couldn't make ends meet, or I called defense, So what I did early on in my career when I was broke, I started making my own exhibits because I couldn't afford to do animations and I couldn't afford to do videos. Now they're much more affordable, like I said earlier on, but I started doing it myself. And I found that if I could get like a skull from Amazon, I could cut, or back then they didn't have it. I could get it from, 3D Scientific or whatever. I could cut it myself to show, the fracture in the head. I would match it up to the x-ray. I had no experts yet. I just had an x-ray that I got, we ordered it, I got it. I ordered a skull, and I matched the x-ray to the skull, and I tried to, cut, some way to demonstrate where the skull was fractured. I took a picture of that, and I'd send it to the insurance company. That's how I was settling cases, to demonstrate, oh, this is how bad the fracture is. This is what I'm going to show the jury at trial, and so stuff like that. So that never left me. So what I see a lot of attorneys doing is they don't do anything. They just kind of take the depositions, they hire experts, they leave it up to the experts to come up with the opinions. Then they take those opinions, they try to get creative a little bit with how they're going to argue it, and then they go to trial. We don't do that. And I'll tell you, it's hard for an attorney like me. And again, I just want to stress to you, and this was not easy to get to this point. We know who the big attorneys are, okay? We know who they are. I'm not going to mention names because we've been hearing about those names forever. That's all I would ever hear about. Oh, such and such did this, such and such did that. Okay, for me, as a small, nobody back in 2009, 10, to now be amongst some of I hang out with these guys now. We're together, I'm on the, so much. They're calling me, I'm busy now, pressing decline. Before I couldn't even talk to them. I would be so happy just to see them once a year at Cala Vegas, you know what I mean? The way that I was able to do that is being resourceful, not having money, trying to find ways so that I could creatively and in a creative way articulate my position to the defense, to the adjusters, and if they didn't believe me, ultimately to the jury. And that's what we started to do. And now with the use of these animations, plus the day in the life videos at a reasonable cost, it's like we're lethal. Like we get in front of a jury, it's over if the defense doesn't pay. Let me show you what I mean. Give me exhibit 1, please. So having said all that, first thing I did is I realized that liability's got to be addressed. So here's what we realized. So I call up Jerry. I'm like, Jerry, the street was damn dark, man. Defendant couldn't see this lady. Like, what's up? He's like, yeah, it's dark, but she was in a bus. The bus had lights on. I'm like, yeah, the bus had lights on. It's a good point, you know. Obviously, it was 6 a.m. in the morning, and he started telling me, and I've never seen a more passionate attorney than Jerry Marcus, ever. The way that he worked this case up, guy's got 1,000 cases. I don't even know how many, Jerry. Whatever, it's a lot. You know, he's got a big firm. Guy, all he was doing was working on this case for like a long time. And when I came into his office, I was like, oh my God, like he's really like, there was a room dedicated to this case. And it was full of like boxes and stuff. And I love information. So I immediately just jumped into it. I went there and I sat there and I just started looking through this stuff. And I would plan to be there for like 2 days. I would open one folder, look at 3 documents. He would come in and we'd talk about that one picture for like a week, you know, like what it meant and this and that. So before I got to looking at all the information, we realized that there was something there. We knew that they were saying it was really dark and the bus driver could not see the plaintiff. Bullshit. The bus had lights on. At first glance, she must have seen the plaintiff. We know that the bus driver hit the plaintiff on a dark road. We know that it was 6 a.m. If it was so dark she couldn't see her, the lights had to have been on. Took her depo, said the lights were on. So what did I do? Drawing on everything that I just told you a moment ago, I'm like, I'm gonna make an 2-scale exhibit of the front of the bus. 2 scale means the headlights are off the ground, how many ever inches they are on the real bus where there was a site inspection done with measurements. I ordered the lights that go onto that bus, and they were right off the ground, 36 inches or something like that, which is what the bus was, and they were like, you know, 4 feet apart or something like that. So here's how we proved that at the very least, the driver of the bus should have seen the plaintiff. So this is me building the frame to the front of the bus. This cost me $80, okay? $80. Now, I borrowed some tools from my neighbor. I have some of that, the saws and stuff, but I cut this frame. Okay, so this was the bus. The lights are off the ground. Those are the lights on the actual bus itself. There's the back of it. And just some wood and some screws and some creative ideas. And then what I did, I painted it. I didn't have to do this, but I did it anyway. Just because I thought it was cool. I thought it would be a nice touch. You know, just so it looked like it, because I was gonna use this at trial. What I was gonna do is I was gonna bring this, put it in front of the jury, ask the judge to turn the lights off on the courtroom, and I was gonna turn the lights on and then stand on the other side where the clerk is, and so the jury could see me, you know, with the lights in front of me, and they would be behind the exhibit. But I painted the bus yellow and all these different things, and then after that, I called my mechanic locally where I take all my cars to, and I asked him, I'm like, can you help me with something? He goes, bring it in. And so I brought it in. And I posted this on Instagram because I knew the defense attorney was following me on Instagram and I wanted him to see what was coming. Okay, I did that.
All right, you're giving it some juice.
So I bought a battery. It was like $100. They did it for me. Got the battery. They wired it for me. And the defense attorney did call me. He goes, what is that? Is that our case? I'm like, damn right, it's our case. This is what's coming. And that's how we got their attention in the first place. He's like, well, you know, there's no liability. I'm like, yeah, there is. Just give me like 2 weeks. And then here's what we did. So this is the front of the bus. There it is. Can you guys see that? Is it coming up on the screen?
Yes.
Yeah, okay. So I called Jerry. I'm like, Jerry, listen, let's take this bus, this exhibit that I made, let's drive it to Antelope Valley in the middle of the night, and let's put it on the road and light it up and see what it does there. And Jerry's like, okay. So I call up our expert. Again, everything's like extremely confidential in this case for some reason. But I call up the expert. I call up Brady. I'm like, guys, can you guys meet me at the scene of the incident? I want you to see with your own eyes. So when your depositions are taken, you could say, yeah, I was at the scene with an exemplar of the front of the bus and there was enough light. And so, okay, this is the actual bus. Let me show you a picture of that. And so we took those measurements and what we did, oh, sorry. Okay, what we did was I matched the measurements of the light to, so our exhibit put those exact lights from that bus onto that board that I made. So we have the exact lights. Let me show you what we did next. So everyone comes over to my house. I think it was around, late at night, one night or whatever, earlier this year. And we rolled out the bus, and here's some of the video of us at the scene.
Face it this way? Yeah, just for right now, just away from the moon, I think. Here's the high beams.
So there's the road.
I built it. Yeah. Where's my phone?
Okay, let me show you this next video. So the street, before you press play, the street is dark. So now what we have the exhibit. I took it there, I put it on the street, and it's dark. And here's what I did. We turned the lights on to see whether the plaintiff could have been seen. I asked Jerry to stand in front of the bus, and here's what happened.
Okay, go down. All right, hit the light.
Okay, stop it right there. Okay, now, first point. When the defense attorney tells me that the street was so dark, even with the bus driver's lights on, the plaintiff could not have been seen, wrong. That argument, that defense, I knew it was bullshit. It was just something that he was saying to me. Have you ever been out there? He asked me that. I'm like, I hadn't yet. Oh, I went out there with the lights on. You can't see anything. Yeah, you can. The bus driver testified she was going 10 to 15 miles an hour, or even slower than that as she approached the intersection, which you could see the stop sign. You could even see the stop sign up ahead in the distance in the middle right of the picture. And so she was slowing down, and you could clearly see an outline of a person if you're going that slow with the exact lights that she had. Continue to press play, please. I mean, can you see that person? If you're a juror and I show you this and I say, oh, they said she was invisible, and he's wearing black, that's what she was wearing. Black top, blue jeans.
That stop sign.
Okay, so this is the most conservative. I mean, you could have turned the high beams on. There's a lot more light, but this is the lowest light beam that we used. We went out there at about the time where it was as dark as it would get at night. Again, we did all this for under a few $100. I did have to pay our expert to come out there, and that even I negotiated him. I told him I'll give him like $400. He's like, okay, I still negotiate. I don't just let them charge me $50,000. Like I say something, because I remember what it was like when I couldn't afford to pay them, and that mentality and the fear of having no money never left me. So I'm always conscious of that. So I did all this for what, like $600, $700, something like that. That's a lot to do, and here's why. After we took like 100 videos that night. I'm just showing you some of them. The ones that they're most conservative, show the least amount of light, but clearly you could see the person. The next thing that we did is when we got back, I called Brady, and what we were trying to do is recreate an animation. So we started going back and looking at pictures that were taken by the officers after the scene. Every case has some picture of something. Maybe it's not immediately after, site inspection, some kind of evidence. So in our case, we just so happened to have where she got hit. Exhibit 9, please. So, oh, sorry. Okay, so here's what we realized. There's the bus. Behind the rear driver's side of the bus, you see clothes that were cut off from the plaintiff's body where she ended up. There's blood on the ground. Remember, she got ran over. She's like 100-something pounds. She got ran over by a bus, okay? Like run over. Everything was fractured. Like, so, that's where they cut her clothes off. You could see some jeans in the bottom right of the picture or whatever it is and whatever have you. What we realized was she was walking in the direction that the bus was driving. Her home was on the other side of that stop sign. She came from a house down the road, and she was walking in the direction the bus was headed, and she was run over from behind as she was essentially walking somewhat in the middle of the street. When we saw that, we started taking depositions of the officers and everything and, whatever have you. And Jerry was able to establish that she was hit not by darting out. And the reason is this: we realized the following. If you dart out, you usually dart out from an intersection. It's an intersection. It's like a T intersection, and you dart out from one point trying to cross over to the other. She had no reason to go from one side of that dirt road that you see there to the other side. She had no reason. She was walking down to the other block because her house was on the other side. So we realized she was walking on the pavement, headed in the direction the bus was, a little bit towards the middle of the street, or a little bit to the left of the dirt road there. And she got ran over by the bus driver from behind when she was clearly visible by the lights of the bus. And we put all that together. It was not too dark. It was not a dart out. She was walking home. We mapped it out where her home was and where she was coming from. So clearly, she was walking that way. And now, all of a sudden, just through some minimal, creative, very inexpensive ways of looking at the evidence, some creativity, we realized this woman, even though she was a crackhead, she got ran over from behind by a damn bus through no fault of her own as she was walking home. So I was like, okay. However, here's the disconnect. Again, this is somewhat I'm using this case to talk about concepts of every case that we litigate. They're the same. They're there. If you can't do this stuff with some of these cases, it means it's a bad case. It doesn't have good enough facts. You got to have some facts that you can unearth. So the disconnect came with, if I call up the defense and just told them what I just told, or told them what I just told you, they're going to be like, F you, dude. We don't see it that way. It's a zero liability case. Okay, Jerry, I want to ask you to tell them, how many times have you talked to the defense without mentioning names and they told you you got a shit liability case?
Yeah, the defense counsel came into this case way before I filed the lawsuit. Right after the government claim was filed, they retained their counsel. Letter after letter, there's no liability, we're never going to pay you a cent, through our pre-lit demand for settlement, denied, we're never going to pay you a cent, through multiple depositions after I took the defendant's depositions, which went really well, and the really important to prepare the plaintiff for her deposition and turned her into a likable person, really humanized her. And even at that point, when we talked about settlement, their view of the value of this case was literally 10% of what we felt the value was, and that we ultimately got.
That's right. Okay, so talking about the defendant's depo, another nice thing that happened was Jerry took the defendant's deposition and asked her what part of the bus impacted with what part of the plaintiff. Here's what she put. She put an X in the middle. You could see that top photograph. That's an exhibit from the deposition that's going to come up here in a second. There it is. She put an X right there. I was like, wait, what? We know that our client was walking on the asphalt. There's evidence of, where she got hit, where her clothes ended up. We knew she was walking home. She was walking straight, not crossing the street. And she got hit with almost, 25%, almost halfway through of where the bus is, which tells us that either the bus was hugging the center of the road, or it was doing, it was clearly, it wasn't like a nick of any kind. She didn't barely tap her. She ran her over with basically, halfway through the center of the bus. And so we felt that that was a good fact because it showed that the bus was even, the point is this: she didn't just clip her, she ran her over, and she could have went around her had she seen her, which she should have. That's the point. Okay, that's the point. All right, you could take that down. Now, after we have all this, we know what the defense was saying about it all. So we put this animation together. We had the light. We knew what the lighting was. There was testimony that the plaintiff was holding her phone, and it was dark. So we had the lighting. We know which direction she was going. So we did a preliminary animation of the incident that looked like this. So we did a preliminary animation. And again, don't think that these are some crazy $1 million, I guarantee you, if you want to get these done, you can call and tell them your budget and work with them, okay? So, a lot of people think, I used to think it, when I used to go to the Cala seminars, 2012, 13, I'm like, wait a minute, I can't afford to work up a case like this. This is crazy. Like, what are they doing? Are they showing off their case? Like, what's going on? They're telling me something that they did, trying to teach me something that I can't afford to do. And I used to get pissed off and leave. I'm like, oh my God, they're just wanting, But, and some of that's true, but I want you to know, I'm not trying to do that. You can do this stuff, you could do this stuff. If you can't afford it, strike a deal, do something. You can make it happen. I'm telling you, if you just call, go meet with them, have lunch, sit down, let them get to know you a little bit. You could put together deals that can give you these kinds of tools. Okay, so this is what we came up with. Bus is going down the road. There's the plaintiff with her cell phone. There was some testimony that you could see it from a witness or whatever it is. And she's walking somewhat in the middle of the street and she gets hit. That's the right amount of light. That's exactly what she was wearing. And that's the point of the bus that the defendant drew an X on that impacted her. So right now we've got something where I know I'm going to have foundation for this. It's what happened. It's the right amount of light. And if I play this for a jury, they're going to be like, yeah, she got ran over from behind. But the defense doesn't know that I have this. So I kept it. And what we did was, here's another view. Okay, so this was a top-down view. And again, we took a lot of video, a lot of pictures that night to demonstrate the lighting. And that's about what it was. So we animated that. And that's what happened in the incident. So now all of a sudden I knew that their defenses weren't going to hold up because this is what happened and no one can dispute that. They can't deny it. I don't care if she was cracked out, high, on meth all night, whatever it is, she was just walking home. I'm sorry, even if she's a drug addict, she's still a human being. And we represented her, and I was not going to, neither Jerry nor I were going to let them, shit all over her because of her socioeconomic status. She had made some bad choices in her life. She was raised in a trailer park, and what's she supposed to do? Poor thing. She never had the opportunity. And I told this later on to the defense. I don't know if they cared or not, but she was born in this environment, so that's what she became. If I was born in a trailer park, I guarantee you I would probably still be there. I don't know, like it wasn't her fault. So, but what I know was not her fault for sure was this incident. Okay, so that's the liability. Let me move on for a moment. That's how we dealt with that. Then we got into the damages, and let me go through this quickly. So she had a tremendous amount of damage. I mean, she was run over by a bus. So I called up Brady and I told him, I'm like, listen, dude, I don't know what's going to happen to this case. We're going to go to trial. I know Jerry's put a ton of time on it. I need these animations and, I need them now. And I want you to work on them and then we'll discuss it, just make it reasonable and we'll pay you. And he said, okay. And he gave us a proposal that Jerry and I thought was extremely reasonable. And we paid it. And before, let me say this, for example, if you can't pay it, there's times where I couldn't pay, these animation bills where I needed to have them for trial. Now we have places like Rock Point. We have other funding places. You can get money for, a certain amount of time that's relatively cheap. I don't know if clients are okay with that. We've done it a few times when we had to. We pulled in our client. We're like, listen, we know that you want us to represent you, think you trust us. I don't have the money to pay for this stuff. I'm going to borrow the money. And if I do that, I finance the costs Here's what I have to pay them back. It's like a 1.2 multiplier or something, 1.3. They're cutting me a deal. Are you okay with that? And we disclose it. We're just honest. And they're like, oh yeah, I'm so happy you're doing this, that. So point is this, there's ways to do this stuff. I know it because I did it when I didn't have it. So there's ways to do it. Okay. Now, she had horrific injuries. Jerry, tell them about some of the injuries she had, and then we'll get into the videos here.
Well, she had, from head to toe, she was run over by the entire bus by 3 of the tires, and she had mild traumatic brain injury, fractures of her skull, her face, punctured lung, multiple fractured ribs, crushed pelvis, fractured femur, tibia, fibula, all required surgery. Everything required open reduction, internal fixation. She was hospitalized for approximately 75 days, and that was just the beginning. What took place after that was the recovery and potentially needing to have one of her legs amputated, which wasn't, but she was a mess.
So I call up, Jerry and I call up Kelly, and we're like, Kelly, is amazing. So we call up Kelly, this trial date is set. They want to mediate. Because I kept telling them, I got all this stuff, like you guys are dead, like, in a nice way, we're joking. I was joking with the guy, but I was semi-serious, very passive aggressive, and I was trying to be nice. And you know what? I love defense attorneys that are my friends. We spent 3 years together in an airport, flying all over the country and taking depots and stuff. But still, at the end of the day, they're not going to tell you stuff, and they're going to hide stuff. They're going to try to, do weird stuff, and they're going to lie to you about how they're getting authority and stuff like that. In my experience, okay, in my experience. So I'm very careful of that. So I knew they were having problems with authority. I knew that they were beginning to reconsider how they evaluated the liability split. It was not 95% on plaintiff, 5% maybe on the bus driver. I knew that when I got involved and Jerry and I started deposing, the treaters and they knew we were doing medical animations, they started taking it real serious. However, they like I said, right from the beginning, they started wanting to take it seriously in their heads, but they still had nothing to look at. So after we addressed the liability in the way that I said, we call up Kelly and we're like, Kelly, here are the depots. Here are the animations that Brady did on the damages. Here's some of the photographs. The plaintiff is at this, Jerry had her up in a hotel because she was homeless. She was homeless. So we were taking care of her. Jerry was taking care of her. He had people there all the time, feeding her, making sure the wounds were clean. I mean, he took care of her, and we were conscious of where she was at. He was handling her. I was, doing some of the legwork that was left to be done, and we were just talking like 5 times a day about what was going on. But anyway, so I call up Kelly, I give her all the info, and we set up a day in the life kind of thing where she could come and shoot her with all her injuries and stuff when she was at this hotel. So she read everything, and again, guys, this was not extremely expensive. I don't want to speak for the vendors and stuff, but it was, in my estimation, very reasonable. So here is the settlement video that we ended up giving the defense. And I want to tell you about the story when we were at mediation, once we showed it to them, what their reaction was. All right, Brady, if you can go ahead and play it. It's like 10 minutes, but this is what the point of it while he's queuing it up. I'm going to start doing this. Well, I have done this on most of my cases, but I'm going to start using these to start settling my cases because they're extremely effective.
In the early morning hours of November 3rd, 2017, Jane Doe walked eastbound on Avenue V10. When suddenly and without warning, a Metropolitan school bus violently slammed into her, knocking her down and running her over.
Making its rounds along the route here on Avenue V10, and it was pretty dark outside. That woman, she is clinging on to life right now. DHP saying she's in critical condition.
She said we had just hit a person.
She hit her and rolled under the bus.
bus?
She looked like she was underneath the bus, and there was blood all over her head.
Witness Joseph Smith saw the bus turn onto Avenue 10 and watched it head towards the middle of the road. From 400 feet away, he saw Ms. Doe walking in the bus's headlights.
I thought, hopefully this bus driver sees this person. And the lights were just outlining the silhouette. And next thing I knew, I just saw the accident occur.
But for some inexplicable reason, Metropolitan bus driver Carla Coe claimed she did not see Ms. Doe until it was too late.
And pitch dark out.
Yes.
You did not have your high beams or bright lights on, correct?
Correct.
Joseph Smith also saw Miss Coe turn into Ms. Doe instead of trying to swerve away from her.
And you did not swerve your steering wheel to the left away from her?
No.
You swerved to the right, not to the left, correct?
Asked and answered.
It's hard to imagine why anyone would choose to swerve into a pedestrian rather than away from them. And yet that is exactly what Ms. Coe did. Avenue V10 is a two-lane, unmarked residential road with no sidewalks. The physical evidence and Joseph's eyewitness account prove Ms. Coe was driving on the wrong side of the road. She was in direct violation of California vehicle codes by not driving as close as practicable to the right edge of the roadway, and by not using sufficient light or high beams while driving in the dark. Ms. Coe is a seasoned school bus driver, yet despite completing 10 or more hours of safety training every year for the last 20 years, Ms. Coe chose to disregard that training and not follow basic driving rules and regulations designed to keep people in the community safe. She also chose not to tell her employer she was undergoing pain management care for chronic pain due to the multiple spine surgery she had prior to the incident. CHP inspected the bus on scene and cited the Metropolitan Schools Transportation Agency for violating air brake safety standards. They also noted badly worn tires, an odometer with over 300,000 miles on it, and missing surveillance cameras. As a direct result of the incident, Ms. Doe suffered multiple life-altering injuries, including a skull fracture.
Okay. So before we get into the damages part and wrap this up, I want to tell you, once the defendants saw that, I could tell you that Jerry and I watched them watch that. And they're looking at it, and that great defense that they thought they had, all of a sudden they looked at each other and they were like, oh shit. And the first thing that they said is they were begging for a copy of this video. They wanted to have it. Jerry, I know you got to cut out, but yeah. Tell them how bad they wanted it.
Yeah, so at this mediation, obviously we were in separate rooms. Eventually they didn't come up with enough money, and we told them about the video. They wanted to see it. We said, okay, you have to see it with us present in the same room, which ordinarily we would let them watch it on their own, but we knew it was that good. We wanted to see the impact.
Yeah.
And so we sat, it was dead quiet, and they watched this video, and you'll see the rest of it with the damages, but you could have heard a pin drop, and they looked at each other. We said, what do you think?
They knew they were in trouble. They
knew they were in trouble.
They knew they were in trouble. They knew that case that they thought they had, they didn't have. And it was this video and all the stuff that we went through up to this point that did it. It made a huge difference because the case settled very shortly after that, very shortly. They begged, I didn't want to give them the video just to be kind of,
right.
I didn't want to give it to them. I knew I was going to, but I wanted to act like, no, you can't. Because I was mad because they did some shady stuff that I didn't like. I'm like, all right, fine, you can have it. Because I know they needed it to go get authority because they knew that we had the better case and they actually had no defense. All right, let's play the rest of it and wrap this up.
Fracture and brain bleed resulting in a traumatic brain injury. internal bleeding from lacerations to her liver and spleen, a laceration to the muscular wall of her colon, a collapsed lung, a ruptured bladder, acute trauma to her kidney, an avulsion to her left ovary, multiple rib fractures, a left femur fracture, extensive death of muscle fibers and compartment syndrome in the left lower extremity requiring multiple vascular surgeries, and a significant crush injury to her pelvis with multiple pelvic fractures. Upon arriving to the Metropolitan Hospital, Ms. Doe underwent emergency surgery to control the internal bleeding. She then underwent many more surgeries in order to save her life, including surgery to repair her skull fracture and brain bleed, an exploratory laparotomy to repair her spleen, liver, bladder, pelvis, stapling of the sigmoid colon, removal of her left ovary, repair laceration of the iliac veins, a resection and creation of a colostomy was needed, and a gastro-feeding tube was also inserted. She also underwent surgery to repair multiple pelvic fractures, bilateral superior and inferior pubic rami fractures, fracture to the left sacrum ala, and diastasis of the right sacroiliac joint. And surgery for an open reduction and internal fixation of the distal femur fracture. Ms. Doe now has a permanent plate and screws in her leg. Ms. Doe spent 8.5 weeks at Metropolitan Hospital suffering from her terrifying and life-altering ordeal. She was transported to the Transitional Care Facility, then Valley Care Center, until she was discharged on March 11, 2018, for a total of 4 uninterrupted months in the hospital. At the age of 32, Ms. Doe can no longer use a bathroom to eliminate waste. She has a colostomy which passes waste material and gas through her abdomen. And instead of using expensive colostomy bags designed to collect the waste, Ms. Doe wraps a diaper around her torso. In addition, Ms. Doe must restrict her intake of solid foods, forcing her to mostly eat soups, Ensure, or other liquid meal replacements. As a direct result of the incident, Ms. Doe has lost her sense of smell and taste, eliminating her ability to derive pleasure from food.
That's how I am, like mentally, emotionally, everything is drained, exhausted, because I'm in constant pain, like constant pain. From my hip to my foot, my head, my lungs, pain.
It has been 2 years since Ms. Doe's tragic incident, and every day since, she has lived in unbearable pain. It's painful for Ms. Doe to walk, to sit, to bend. She has constant pain in her stomach. Her pain is so excruciating, sometimes it's paralyzing. She passes out or vomits. At night, she can't sleep because the pain is insufferable.
I just couldn't do anything. I couldn't do anything. It hurt so bad.
Currently, Ms. Doe walks with a cane, and she wears a boot. Without it, she can't put pressure on her foot. Due to the severity of injuries caused to her leg when she was run over, Ms. Doe's leg has poor circulation. She says it is constantly freezing cold and painful to the touch. Doctors anticipate her leg will need to be amputated in the future. Ms. Doe's life care plan, prepared by rehabilitation expert Jan Rohan, states Ms. Doe's injuries significantly compromises Ms. Doe's participation in normal life experiences, and the extent and severity of her disability have imposed permanent alterations to her self-care, vocational, educational, social home maintenance, leisure, and recreational domains. In addition, she will require long-term medical management by a sophisticated interdisciplinary team of specialists. Ms. Doe's life plan includes procedural and surgical interventions such as knee amputation and bowel repair resection, future medical care including but not limited to neurologist, vascular surgeon, and pain management specialist, ongoing diagnostic evaluation, psychological services, and transportation needs. The estimated overall lifetime cost is expected to exceed $24 million. Ms. Doe was also evaluated by defense expert Dr. Topher Stevenson in September 2019. His opinion supports Ms. Ruffman's life care plan, but goes even further to recommend in-home care and 24-hour assistance to begin immediately and last her lifetime. Dr. Stevenson also believes Ms. Doe will not be able to enter the workforce due to the significant injury she sustained. Life for Ms. Doe was never easy. At a young age, she lacked the positive role models she needed to believe in herself. She was forced to go out into the world on her own, and yet she maintained hope for her future. That is no longer the case. No human being deserves what happened to Ms. Doe. In an instant, any hope of a future was taken. Her life and her body was destroyed. As a direct result of Ms. Coe's failures to follow basic safety laws, Ms. Doe will never be the same. We may never know why Ms. Coe swerved into Ms. Doe instead of away from her, and we may never know why the Metropolitan School Bus Transportation Agency didn't properly maintain the bus. But what we do know is this tragic and devastating incident has completely altered the course of Ms. Doe's life forever.
All right, so we have a ton of questions, but before I take the questions, I just want to say, you know, remember when I was first telling you guys about the case? Just the words alone, I described some crappy liability case versus what you think of the case now after you saw that video. That, I mean, it's day and night. It's day and night. So when the defense, again, when they saw this, it changed the whole landscape. They knew they were in trouble. You're going to put me in front of a jury on these facts? Like, that's not going to end up good for them at all. There was so much there that I had to work with. And until they saw this, they had no idea like what our case was. As soon as they saw it, they begged for it. They were like, please give it to us. They got authority and the case settled like shortly thereafter. And last thing I want to say two more things about this whole situation of, you know, expenses and costs and animations. If they would have seen this, so typically what happens is this: we settled this case, it's over. Typically what would happen is I would have never done this. I would have never shown them anything. They would have never seen any of this. The first time they would have saw a glimpse of what would resemble this video would have been in my opening statement. So many trials that I've been in, right after I give an opening statement that reflects all that, I sit down, we take a break so that they can get ready and do whatever it is they're gonna say or do. Defense attorneys walk over to me, they're like, listen, man, you know, if we knew all that, you told us all that, like this case would have settled. And I'm thinking, obviously you had all the information. I made this, you know, this opening statement, or I made this settlement video based on the depots, but you have to put it into perspective and you got to show it to them if you want to actually settle the case, which is what I want to do. I mean, I don't want to try the case, but I will if I have to, and they know that I can. So that's that. Number two, this stuff's never too expensive, okay? I don't care if your case is worth $50,000. You can create something that has a budget that matches what the case is worth, 10%, you know, whatever it is, you can create something that's meaningful, even on smaller cases. So, but certainly on the bigger cases, 6-digit cases, 7-digit cases, definitely 8-digit cases, I mean, this stuff is extremely effective. All right, what do you guys want to do? Do you want me to answer the questions, or you want to wrap it up? Brady, what would you like to do? I don't know how many people are still on.
Yeah, pretty much no one is left, Steve. So why don't you answer some questions?
Got it. Oh, okay. All right. Obviously you were getting okay. I already answered.
Hey, Steve, why don't you answer one or two questions, and then we'll let Kelly talk for a second. I'll talk for a second, and then you wrap up the questions.
Okay. Oh yes. Sorry. I know you guys have a lot to say about it. Do you recommend videos with settlement demands in the pre-lit stage, and does it have any effect on opening the policy? I don't do any pre-lit. So pre-lit, no one cares. No one cares. I mean, they're just looking at a bill, medical expenses. They discount almost everything. So if you have, you know, we have those cases that are moneymaker cases to keep the doors open. Those, you know, we try to settle them. I would not. No, I do not recommend doing a video like this pre-lit. Any case that is worth, you know, a good amount of money, you have to file it, because as soon as it's in lit, higher level adjuster, defense attorneys get involved, different evaluation. That's what I would do. Why not use an actual bus? I didn't have an actual bus, otherwise I would have. 100%. We tried to get one, but again, you know, we're trying to do, you know, something that's economical and that makes sense. That's why. So it was cheaper and faster for me to just make the lights and do it that way. How do you ensure the defense adjuster mediator will watch your videos demonstrate? I use the mediator, refuse to watch the live. Okay, what do I do? Also, you do opening statements in mediation? No, yeah, great question. We bring them, we made them come to the room. I made the mediator sit there. I made the adjuster sit there, the defense attorneys, both of them, and their whole crew, you know, all those people and the mediator. And the whole point was me watching them watch this. Like they're sitting this way, they're looking at the monitor in the room. I'm sitting and they're looking at the screen, I'm looking at them. And, you know, I could see the adjusters, I could see like just crawling down in the seats, they're like disappearing because they knew it was over. So no, you got to tell them what you have and tell them you're not going to show it to them unless they come into the damn room and you're going to press play for them. Let me do two more and then I'll let you guys. Okay, issue of her walking in middle of road, possibly under the influence, did not give defense a theme of her bringing it upon herself. Listen, yeah, it did, kind of, you know, I know that. She was walking in the middle of the road. You're not supposed to do that. The way we handled it was this. It is a residential street. There is no law that prohibits her from walking on the surface of the street, anywhere that she wants to be. There's nothing that we couldn't find anything, nor could they. And so she had every right to be where she was. Number two, my argument to the jury, and I told this to the defense, and I did not do an opening statement, by the way, in mediation, coming back to that a moment ago was asked. I just played the video for them. But I was thinking about doing an opening statement, but I told them, semi-mini opening, that the reason why she didn't walk on the dirt is because there was cars intermittently parked on that dirt portion of the road. And so she was walking on the road and she wasn't quite in the middle of the street. She was like, if this is the lane of traffic going this way, and this is the dirt road, she was like, here. We're exactly where she should be. How were you able to hide the animation showed at trial from the defense prior to trial? To hide the animation showed at trial? I didn't show the animation at trial. We settled the case. And I don't know exactly what the question's asking, but I show all my stuff in expert discovery. As soon as experts are deposed, whatever I'm going to have at trial, there may be one or two more things, but I'm going to hand it over immediately. Animation's everything. How do you get the voiceover speaker? I'm going to let Kelly answer that. I've heard that guy speak on everyone's settlement video. He's really good.
Hey, Steve, can you would you mind reading the whole question? Because I don't know if the participants can see the questions.
Oh, yes. Sorry. My bad. I thought everyone could see it. The real question is, how involved are you in the details of the video? Do you vet the narrator for quality of voice? Do you vet, approve other details as they make it? No, I'm not involved. I don't vet anything. I used to back in 10 years ago. Again, I did these myself. We'd have a videographer from my wedding. We had the guy, I would sit there in my living room for like 3 days. We'd piece it together. But now we have Kelly, and she's fantastic. And we just trust her. We know she knows what's up. So she gets all that stuff done. I'm going to let her answer that. So I don't have to do anything. That's the beauty of these vendors. That's why I work with them too. There are other vendors. So, and we all work with everyone, but I like the Brady Kelly team because that's what's just been working for me. And we're talking about this one case, but we've settled like 10 of these, this isn't the only one. And it just, the team works. Okay. Do you approve the script in advance? No, do you approve the script in advance in video segment sequence? No, I leave it up to Kelly. At what point do you play this video at trial? I do not play this video at trial. I only play the animations contained in the video at trial and the day in the life of where the plaintiff was in the hotel room. I don't play the video. It's argumentative. I wouldn't even try. I would get all kinds of objections. Again, this is strictly to settle the case, to show the defense what you have. That's all it's for. Because once they see it, it's a different landscape. They have to circulate it to the higher ups, and you're gonna get authority if you do it right. Kelly, there's a question for you, Kelly. The settlement was based then on just medical specials, lost wages because no punitive damages against this defendant. Right. No, it was just non-economic damages and economic damages. That was it. Phenomenal video. What did it cost? Call Kelly and ask her. I don't remember. And, I don't remember. But Kelly, you can call them and ask them. But I'll tell you this. I don't like paying for stuff until I see it and I like it. I got it. She sent me the link. I knew she was working on it. I pressed play. I watched it. I got the invoice. Not too long thereafter. I paid it immediately. That's how much it was worth it. I knew it was worth it. So it was not a big deal. I remember cutting that check immediely.
Kelly, did you want to share a little bit?
Yeah.
Go ahead.
Usually we get very little input from the attorneys. We get the brief. I ask usually, why isn't the defense settling the case? We get super invested emotionally in trying to do right for the plaintiff. I have a team of people that work with us. I supervise every project because I'm from New Jersey, and I am like this the most incredible cynic, right? So when we write the scripts and when we create the videos, I'm making sure that nothing sounds suspicious or out of the ordinary. My main goal is to make sure that we are presenting everything in a reasonable, authentic fashion, right? Nothing was super inflammatory or anything like that. I just want it to be nice and clean and direct. And it's not easy to do. It takes highly skilled storytelling techniques to do this. I mean, in 12 minutes, we covered a lot of ground, and it was incredibly efficient and effective, I think. We work really, really hard, some clever editing, but that expert storytelling, I worked in television for a long time. I have 2 producers on staff that are also TV producers, and our editor and our narrator is incredible. Our narrator has been with us for over 10 years. He knows how to read these things. He knows what we're looking for. And he's an actor he is so invested. Everybody in our team is really invested in putting out the best product.
Can I say something real quick to our audience? So I saw Kelly sometime after this video was put together, and I watched it and stuff. We were at some function. And, I came up to her, I'm like, hey, what's up? What's going on, this, that. She's like, yeah, I'm hearing the case is resolving. I was like, yeah, it's resolving. And she started very emotional, breaking down. That's how affected and personally she took this case. And I'm
every
like,
case.
it's going to be okay. Don't worry. She's going to get
every case.
Yeah, I was like, oh my God, like she really felt it. Like I had to console her for a second. I'm like, don't worry, plaintiff's gonna be good. But that's how vested she was in it.
And Brady's animations, Brady did all of the animations. We simply incorporated them into our production. And those animations, I know there's a lot of choices out there for animators, but I have never ever seen animations this quality. The quality is amazing. And it just rose the production level way high and incredibly beneficial in helping tell the story, the devastating injuries that the plaintiff had.
Yeah, thanks, Kelly. You know, I did see a question in there just a moment ago about the two different services between day in the life videos versus 3D animation. So yeah, they are definitely separate services, but they work very well together if you can do that. You know, this has been really fantastic. Steve had mentioned a couple points about budget. There's been a lot of questions about price. It is extremely rare that someone calls us and we can't strike a deal to get an animation done, whether it's for mediation or trial. The one nice thing about mediation and creating animations for settlement style cases is that the price point's a lot lower. It's a lot lower than a trial-ready animation, usually 50 to 75% the cost of a trial-ready animation. So keep that in mind when you're thinking about using these to settle cases. Yeah, Steve, anything else you want to add? Any other questions that you saw in there that are worth answering?
Yeah, all the questions are worth answering. They're really good questions. I'm getting them from both sides of the screen. From Bob, videos versus stills. I use videos. I never use stills. Sometimes, very rarely, because videos are so affordable now. You know, you get a still for like $800. You can get a video for like $1,800 on something that's canned in the library of the animator. So for that reason, we don't use stills anymore. Let's see.
I just want to say one thing. Anybody out there, just email me what your case is about, what case you have right now. Email me at kelly@verdictvideos.com. That's KELLY @verdictvideos.com. So tell me what case you have. I will send you an exemplar and the pricing on what it would cost for us to help you. So it's just simple. I don't care if you have a rear end, a slip and fall, a trip and fall, whatever you have, an employment case. I will send you an exemplar to show you what is possible, what we can do for you and the price
Great.
for that.
All right, I think we should wrap it up with that. Please follow me on Instagram. Yes, you could, Steve. Brady, if you could send everyone an email with my Instagram page, Steve_Vartazarian.
Absolutely.
And also, anyone is welcome to call me for anything, anytime. I will help you. I will talk to you about your case. We try to help people keep their cases so they don't have to refer them. I would be more than happy to do that. And if financing is an issue, call me. I could set you up with my vendors. It should never be an issue. You should be able to get your hands on this stuff at any point if you need it for your case. I could discuss that with you and tell you exactly what I did to get to where I'm at and get these kinds of cases. I thank you guys so much for tuning in and supporting me, the vendors that I've been on webinars with, and thanks so much. I hope some of this is valuable.
Thank you.
Absolutely. Thank you all. I really appreciate it.